If the court pleases, my name is Karmanpreet Singh and I appear on the behalf of Mr. Graham. To begin with, the facts of this case are fairly simple. One early Sunday morning in January 2020, my client, Mr. Graham, was driving back home from his night-long work. Both the cyclists, Lisa Murray and Noah Singh, were driving alongside Alexandra Avenue, seemingly close to Graham's car when he honked and warned them. Lisa reacted to the honking by yelling at Graham and upraising her middle finger. This angered Graham, who then stopped his car, approached the cyclists, and began screaming at them. Amidst the quarrel, Graham pushed Noah Singh, causing him to fall on the ground and sustain neck injuries. The first point the defense would want to raise is about the provocative behavior of the cyclists. There was no premeditation in the act on my client's part. Conversely, he was cautioning them for being watchful by honking. His inadvertent actions were only in response to the exasperating behavior of the cyclists. My client had been working throughout the night. His sleep wake cycle has been unstable for a while now. Lisa yelling at Graham and appraising her middle finger is suggestive of the outrageous provocation my client had been exposed to. The second point the defense would raise is the circumstances in which Graham reacted abased his autonomy as a driver. My client is a big time supporter of drivers' rights and is very vocal on the social media about his views and communicates awareness about the driver's rights. Consequently, he reacted in circumstances which abased his autonomy as a driver. Adjournment of the case with no conviction recorded should be considered, acknowledging the instigating circumstances in which Graham reacted. The sentencing principles which apply to Graham's case are that of rehabilitation. Graham's attempt of redressing his anger issues by enrolling in an anger management course should be addressed in the sentencing. His age, employment, no prior conviction, and his expression of remorse exemplify strong prospects of rehabilitation in an unsupervised community under Section 71, subsection A of the Sentencing Act 1991. My client is of sound character. He is a devoted professional. He has been working for Linfox for nearly 20 years until 2018. From 2018, he has been working for a large online retailer as a delivery driver, often working till late, which is suggestive of his determination and compassion towards his work. No prior conviction and a clear driving record is suggestive of his preceding compliance with the legal system. The sentence the defense would recommend is adjournment of the case with no conviction recorded. The recording of the conviction would severely undermine my client's reputation and employment prospects in the future, bearing in mind his age. Adjournment of the case would assist my client in undertaking rehabilitative procedures, um, which would also benefit his health situation, which is that of a high blood pressure as of now. Commensurate with the current sentencing practices, nearly 10, that is 5.5% people in the age bracket of 45 to 54 were awarded an adjournment by the Magistrates Court for an offence under Section 18 of the Crimes Act 1958. Additionally, my client's high blood pressure problem negates the probability of being awarded with a custodial sentence. The prosecution recommended that a fine be imposed on my client. Fine in any case would not assist in achieving deterrence or rehabilitation. Fine would, to an extent, impinge my client's financial credibility because his current source of employment is not very secure. In conclusion, my client's age, employment, no prior conviction, and his expression of remorse exemplify and augment strong odds of demonstrating good behavior under Section 75 to subsection B of the Sentencing Act 1991 if an adjournment is awarded. Thank you.